Next on our agenda, we're quickly approaching the 25th anniversary of an historic Supreme Court decision that continues to breathe life into the work of cartoonists, artists, and writers. Roslyn Mazer was a young law partner in 1987, and I was a young cartoonist in 1987, when she contacted the AAEC to alert it that the court had agreed to consider a case pitting the evangelist Jerry Falwell against Hustler magazine publisher Larry Flint. The details of the late Reverend's complaint are well known. Roslyn's contact led to the first case in which the AAEC fought in court to protect the First Amendment. As we approach this quarter-century milestone, we invited Roslyn to be here tonight to tell the story of that adventure and the vital ruling that continues to safeguard our work. But before we do, I give you Mike Peters to give a further introduction.
Now, you've got to understand who this lady is. 30 years ago, was it, or 25? You know, there was a bunch of us cartoonists, a handful maybe, or 6 or something like that. We had done Ready Kilowatt, you know, in cartoons. And the electric company came out and said, no, you can't do that, I'm suing you and stuff. And she went to the Supreme Court, went all the way up to the Supreme Court, and this lady changed the laws for us, made it so that we could use satire. We could take these copywritten characters and use them in our cartoons to say something, and she made it legal. She made this legal for us. And then 10 or 15 years after that, the Hustler case came up at the same time. Came up, and then that was another brick in the wall that you helped build for us cartoonists to be able to use satire and use copywritten material. And so it's a big thing. But personally, for me, a couple of years ago, she and her fabulous husband, David, in my comic strip, Mother Goose and Grimm, I was doing this stupid thing. Some guy had, I read, the guy who invented the Pringle can, the Pringles, and they have the little Pringles things. And when he died, he wanted his ashes buried in a Pringle can. And I thought this was hysterical. And so then I had one of my characters, worrying about every box of things that he had, if it had the little ashes of somebody in it. I don't even remember what the things were, but I remember the last one that caused me the problem. I had Mother Goose starting to make some coffee, good hearty, coffee, and Colombian coffee, and one of the characters said, I wouldn't do that if I were you, and she said, why? And he said, well, they have the Colombian mafia in Colombia, and when they say there's a little bit of Juan Valdez in every can, it may be, Well, I seem to have touched a nerve. And I think it was more than just, oh, that's bad. I think it touched a frigging nerve, because the Colombian coffee people sued me for $20 million. And they got a big-time law firm in New York to contact me and say, okay, they're suing you, and be ready to start going to court, and we're going to start, testifying and all this kind of stuff. And I didn't know who else to call, but I called my buddies, David and Roz, who had kept me out of jail the first time. And David said, I will start working on this. And went through for a couple of months, and David was talking to the coffee makers and saying, you don't really want to sue them for $20 million and stuff. And then I had cartoonists calling up saying, yeah, fuck him, that's great, go to jail. I said, well, that's great, 20 million, that's terrific for you to say. It's 20 million. I don't have 20,000, and so so finally, he got them to agree. No. They came to me and they said, okay, we will drop the suit. Just come to Bogota so we can talk to you ourselves. And David called the State Department, or the State Department called him and said, no, that's one thing you don't want to do is have that cartoonist go to Bogota. I was on every paper in Bogota. I was a big thing in Bogota, to the point where I went to lunch with John Glenn at the congressional golf course. And he said, and Mr. Senator Glenn, who I had known many years, said, "Here, sit down," and stuff. And we're eating, and he said, "I want you to meet my head chef that always serves us." He says, "Come up here, Jose, or whatever his name is." And he said, "This is Mike Peters." And the man said, "Oh, I know who Mike Peters is." He said he'd been on front page for months in my town. So this is the lady who has saved us many times so that we can use copywritten material in our cartoons without getting sued. And she and her wonderful husband saved me from going into the poorhouse. So here she is, Roz Mazer. Please give her a hand.
Well, good evening, everyone. 25 years ago, the funny business of cartooning hit a very serious patch. In 1987, as John said, this association participated for the first time as a friend of the court in a case before the Supreme Court of the United States, and a very fine friend it was. Through a remarkable series of coincidences I want to tell you a little bit about tonight, I had the opportunity to approach the AAC through Jim Moran, the cartoonist for the Miami Herald, who, as it happens, was the son of one of the senior partners in my law firm, about the biggest threat to cartooning and satire in a generation. That conversation with Jim Moran led AAC to hire me to tackle what the mainstream media, MSM, regarded as a very worrisome legal controversy. A federal jury in Virginia had awarded Reverend Jerry Falwell a $200,000 damage award for intentionally inflicting emotional distress on him when it published an ad parody in Hustler magazine. The parody was a photo of Reverend Falwell, accompanied by faux dialogue based on the old Campari liquor ad campaign, "When Was Your First Time?" with his mother in an outhouse. You know where that goes. It was vulgar, it was cruel, and certainly not the type of publication that would cause members of the Supreme Court to chuckle. What was so worrisome about the Virginia verdict was that it was based not on libel, which, as you know, requires public figures to prove a false statement of fact that was published with knowledge or reckless disregard of the truth or falsity, but on a claim of intentional infliction of emotional distress. Under Virginia and other state laws, that cause of action did not require there to be a false statement of fact in order to succeed. So to commemorate the 25th anniversary of the Supreme Court's decision in Hustler v. Falwell, I have a few fun slides and one amazing revelation to share with you tonight. This is the cover of our brief. In 1987, after the court agreed to hear the case, and contrary to the conventional wisdom, which said that we shouldn't even bother to pitch our case toward the Chief Justice and other conservatives on the court, together with my law partner, George Kaufman, we decided that was the only way to prevail. So I'm going to show you a picture and see if you recognize Bill Rehnquist from his high school yearbook, with thanks to Shorewood, Wisconsin's yearbook, the Coppertone, 1942. I had heard that the Chief Justice was a fan of cartoons and of good humor in general. And I knew from other decisions and from their books and speeches that he and Justice Scalia were great students of American history. As a result, we devoted half of our brief to depicting the role of satire in American politics. We talked about how the founding fathers were subjected to vicious attacks, how cartoons and caricatures have been central to public debate, of course, not only in the United States, but going back many centuries abroad and beyond. We developed a few friends along the way, though the mainstream media was slow to join our cause. In a particularly powerful editorial, the Washington Post talked about the brief that we filed and urged the court to reverse the lower court decision. What was really remarkable was my engagement with the association in developing the brief and in deciding ultimately to include an appendix of political cartoons. I elicited or solicited the membership of AAC to send me cartoons. I remember Ben Sargent, Mike Peters, others who are with us tonight sent me all sorts of things. The criterion I'd established was send me a cartoon that would make the subject cry. Here's one I did not include. The late, great Paul Conrad sent me this cartoon by FedEx. It arrived the next day, and you may remember that in about 1986, then Associate Justice Rehnquist was nominated by the President to be Chief Justice. And during his confirmation hearing, a controversy about a restrictive covenant in his home property came up. And so here's his valet with two robes on his arm, asking then Associate Justice Rehnquist, Justice Rehnquist, will you be wearing your hooded white or your black robe today? Now, I remember Kahn called me the next day. He didn't say who he was. He just said, hello, did you get it? And I said, yes. And he said, are you going to include it? I never met Conrad by that time, and I equivocated. And he said, fuck, you should include it. And he hung up on me, you know? So that was my introduction to Conrad. Fast forward to the 200th anniversary of the United States Constitution. I had the privilege, by accident, of sitting next to Chief Justice Rehnquist at a dinner in Williamsburg. And he was chit-chatting, small talk. Have you ever been before our court? I said, yes, in one case. And when I said it was the Hustler case, he brightened, and he said, well, what were you doing? I said, I wrote the cartoonist brief. He said, oh, that was a very effective brief. And I said, well, you know, we're thrilled with the decision, but I always wanted to tell you about a cartoon we didn't include in the appendix. And so I did tell him the story, and as you might expect, he was so charming and welcoming, and he said, oh, you should have included it. No, but I don't regret the decision that we made. So I wanted to share with you a couple of as yet unpublished drawings. On the day of the Supreme Court argument, December 2nd, 1987, it was cold and dreary. A few days before, maybe even the day before, Pat Oliphant called me and said, well, are you excited and are you going? And I said, of course I'm going. He said, well, can I go? And we quickly contacted the press officer and arranged for Pat to be in the press gallery. He'd never been to a Supreme Court oral argument. And I took his sketch pad, which he gave me at a wonderful lunch afterwards. And here are three of his drawings. Reverend Falwell, who was at the court, exhibiting his hurt feelings. Falwell's mother. And then one of my favorites, his depiction of Reverend Falwell's lawyer, Norman Roy Grutman, as a whorehouse piano player. Right. So the happy news was in a unanimous decision. The court reversed the award for Reverend Falwell and held that the First Amendment protected the parody, even though it was outrageous to some, because to do otherwise would allow the inherent subjectivity of the outrageousness standard to publish all forms of satire based on the jurors' subjective tastes or views. Then borrowing directly from our brief, the AAC brief, the Chief Justice said, The appeal of the political cartoon or caricature is often based on exploitation of unfortunate physical traits or politically embarrassing events, and exploitation often calculated to injure the feelings of the subject of the portrayal. The art of the cartoonist is not reasoned or even-handed, but slashing and one-sided. The political cartoon is a weapon of attack, of scorn and ridicule and satire. Then Chief Justice Rehnquist noted that the Hustler publication was at best, quote, a distant cousin of political cartoons, but acknowledged that our political discourse would have been considerably poorer without the likes of Thomas Nast and Walt McDougall. The day the decision came down, here's what Pat Oliphant had to say. Dear Mr. Flint, in order to defend their constitutional freedom of expression, satirists are forced from time to time into reluctant association with people like you. In celebration of the excellent Supreme Court decision, Hustler v. Falwell, I trust you will accept the accompanying depiction of yourself as strictly satirical. So there's been tremendous scholarship and genuine puzzlement as to why the Chief Justice not only voted to overturn the decision, but wrote the unanimous opinion. And in getting ready for the remarks tonight and another 25th anniversary event next February, I came upon a study of Chief Justice Rehnquist's First Amendment cases by Jeffrey Stone and Harry Calvin, Jr. The Chief Justice participated in over 259 First Amendment cases in over 30 years on the Supreme Court. This study showed that over that 30-year period, Rehnquist rejected the First Amendment claims 80% of the time. And looking through the narrower lens of cases involving sexually explicit material, porn, and other offensive speech, Rehnquist found a violation of the First Amendment in only 12% of those cases. So 25 years later, it's all the more remarkable that AAEC's courage and its advocacy when the MSM was ready to run away from the fight, enabled the Supreme Court to issue a ringing victory. And what I also learned in the last few weeks is that in the high school yearbook, and I'm sorry, Mr. Tapper looks like he left, but in the high school yearbook, there's a reference to Justice Rehnquist's activities and clubs, you know, the kind of thing they talk about what you belong to in high school. It says, the favorite pastime of Bill in and out of school is cartooning. Amazing. It's amazing. So, I'd heard, I certainly didn't have the benefit of that piece of archival material, but I'd heard that he was a fan of cartoons. So as we now celebrate the very serious business of cartooning in some other countries around the world, I'm so proud to be here, so proud to have represented the association, and you should all be really proud that this decision by the court has endured over all these years and has served to thwart a lot of lawsuits against cartoons and other forms of satire. So congratulations, keep it up.